This is Barry Zalma speaking from my newsletter, Zalma on Insurance. Today we talk about why an arsonist must go directly to jail and not pass go. And when the arsonist, after being convicted, incompetently moves in pro se, acting as his own attorney to avoid prison, his arson for profit scheme developed the chutzpah, the unmitigated gall, to move the court for release. In Christopher A. Barosh versus Morris Hauser et al., the United States District Court for the Eastern District of Pennsylvania on November 25, 2025, a convicted arsonist and insurance fraudster moved the United States District Court, acting in pro se, with objections to Magistrate Judge Reid's recommendation that the U.S. District Judge dismiss his petition to avoid jail. The whole case started in October of 2025 when Barosh set fire to his girlfriend's Philadelphia home some 25 hours before the cancellation of the property's insurance policy. Several witnesses saw Barosh leaving the property shortly before the fire erupted, and after the fire, Barosh made two separate admissions of his guilt. He attempted to pay an acquaintance to provide him with an alibi for the time of the arson. The eyewitnesses, Barosh's brother, and an acquaintance all testified at trial. And in December of 2012, a Philadelphia jury convicted Barosh of arson and insurance fraud, and he was sentenced to 9.5 to 22 years incarceration. The Superior Court rejected Barosh's direct appeal, and the Supreme Court denied allocatur the right to appeal. Acting pro se, Barosh sought post-conviction relief act relief, and at some point, Barosh was represented by counsel. Before the PCRA court issued a decision, Barosh appealed to the Superior Court, which dismissed the claims as premature. The PCRA court then issued a notice to dismiss, and after Barosh filed two more premature appeals, formally dismissed his petition. The Superior Court affirmed, and the Supreme Court again denied allocatur. In April of 2022, his matter was referred to Magistrate Judge Reid for a report and recommendations to the District Court judge. Respondents opposed relief, and Judge Reid recommended that the District Court judge dismiss Barosh's petition because he filed 4 months after the one-year deadline. The District Court judge reviewed de novo that all over again and new those portions of the report to which Barosh files timely specific objections and may accept, reject, or modify in whole or in part the magistrate judge's findings or recommendations. Barosh argued that Judge Reid should have ruled that the limitations clock was equitably tolled. However, the limitations clock is tolled only if Barosh has shown, one, that he has been pursuing his rights diligently, and two, that some extraordinary circumstances stood in his way and prevented timely filing. As a last resort, then, he claimed he was actually innocent, and Barosh argued in the alternative that Judge Reid should have excused his untimely filing because the actual innocence exception applied. An actual innocence claim requires a petitioner to support his allegations of constitutional error with new, reliable evidence, whether it be exculpatory scientific evidence, trustworthy eyewitness accounts, or critical physical evidence. That was not present at trial. But Barosh offered no new evidence. The District Court, therefore, on the 24th day of November 2025, upon consideration of Magistrate Judge Reid's report and recommendation. Petitioner's objections and respondent's response, it was ordered that 1. Petitioner's objections to the report and recommendations were overruled. 2. Magistrate Judge Reid's report and recommendations is approved and adopted. 3. Petitioner's claims are dismissed. 4. A certificate of appealability will not issue. And 5. The clerk of the court shall mark the case closed. In my opinion, I am never surprised that people who are convicted of the most dangerous and violent form of insurance fraud, arson for profit, have the chutzpah, the unmitigated gall, to continue to move the courts for freedom or reduction of sentence without facts or laws supporting their claims. The court did not fall for the attempt, and not to mention the previous multiple attempts, and let the magistrate judge do the work and then refused the application for relief. Barosh stays in jail as he should. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog and the videos, and let them subscribe to the blog and the videos. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.